YouTube. Okay, today we're going to talk about examples of judges practicing law from the bench. Okay, so when you say a judge is practicing law, it's either he's acting as a prosecutor, because obviously, if you are a defendant and he's helping you, you're not gonna call it. You get what I'm saying? The rules of the game is you call what offends you, and they call prosecutor calls whatever they offend them. So practicing law from the bench, it's under 28 Title 28 U.S.C. United States Code Section 454. It's called high treason. So you search up high treason, and depends on how you do your search, what cases you use or whatever. It's a serious offense. It could be capital felony treason. You know, depends how you articulate it. You could put it as treason, as practicing law from the bench is a high, it's a certain key wording. It's a high offense, or it's something like that. But either way, practicing law from the bench is when a judge acts as a prosecutor or as a defendant when he enters a plea on your behalf. So when you go to Rules of Criminal Procedure Law of New York, in there it says that you are allowed not to enter a plea until you've received all the evidence. You go to arraignment. At arraignment, they're gonna say what you're being charged with, and then they're gonna ask you. Usually they ask how do you plead or not plead. They always do it. Once you enter a plea agreement, the certain steps already skipped. So you could say, well, Your Honor, before I enter a plea, you can challenge jurisdiction, nature, and cause. When they say nature and cause, it means the jurisdiction. Nature is in Article 3, Article 1, common law, admiralty, maritime. And then when they say the cause of action, from my understanding, from my experience, it's either civil, criminal, family court, surrogate's court. So you see the nature and the cause, you got to distinguish that. So push come to shove, you're in front of the judge, they're trying to make you to enter a plea, and you say, well, Your Honor, before I can make an intelligent plea, I'm still trying to find out the nature and cause of the action. There's a different argument for that. But once you do that and you go to the nature and cause, then he's like, well, if you're not going to enter a plea, I'm going to enter a plea for you. You're going to say, Your Honor, I object on the record as a mistrial, as an appealable issue, as you practice law from the bench, as a violation of Title 28 U.S.C. 454. That's a felony, Your Honor. That's a felony, Your Honor. You can't enter a plea on my behalf. You're gonna enter a plea on my behalf, then I'm gonna act as the judge, and you're gonna be the defendant. And if that's the case, you need to stand over here, and I need to go sit down over there. He's gonna feel offended. He's gonna feel like you playing games and all that. But the codes is backing you up. You get what I'm saying? So it'd be like, Your Honor, you're practicing law from the bench. If you're gonna act as a defendant, I suggest that you come here and I'll go over there. Because Article 6, Paragraph 3 of the United States Constitution says that you shall oath to uphold this Constitution. And then Article 6, Paragraph 2 of the United States Constitution says the Constitution is the law of the land, and every judge in every state is bound to obey it. So now, if you're practicing law from the bench, I'm going to object on the record as a mistrial, as an appealable issue. Now, don't continue on this subject. You don't continue debating. You save your objections and you continue forward. The only time you go back and forth on the same argument is on jurisdiction. That's the only time. You never leave jurisdiction. Once you leave it, you can save it for appeal. Object on the record as a mistrial, as an appealable issue, and you continue. But from my study, from the Chief Court Clerk of the United States, if I'm correct, or from the Circuit Court, he made a video, and it's on YouTube, and it gives you I believe it gives you the case law. But he says when you challenge jurisdiction, you stay on it to the end. You don't leave that subject. Some people, when they get cases dismissed, the judge will ask them another question like, oh, but did you fix your license? Oh, but you paid the debt already. Like trying to skip it. Or I'll save you for later. You'd be like, objection. Objection, Your Honor. On the record, as a mistrial, as an appealable issue, you haven't established jurisdiction, the nature and cause of the jurisdiction. Now, this whatever type of jurisdiction, constitutional, maritime. Constitutional is common law, and maritime could also be constitution, if you know how to override it. The Constitution overrides everything. It overrides family law, contract law, every law that's out there. The Constitution superrides it, including U.S.C. You override it. I have somebody that I helped. The judge didn't answer it, but we use constitutional law. All our arguments are constitutional to the end, to the heart. There's soldiers out there dying for this, and I don't need to die because they're dying for me, and I'm enforcing what they can't enforce because they gave their lives up for that. So I'm showing them that I'm doing my part as an American. It takes two. God said, I don't know the exact verse, but he says, if two people come into agreement, it shall be so. So the soldiers, every soldier is out there, they should represent one thing, and it's Constitution. And what does the Constitution mean? Life, liberty, and the pursuit of happiness, a free country. So how you got a denominator, number, a multiplication, and all that, and you bring it to the lowest number denominator. So, like, for example, 10/5 is 1/2. So you get to the very end. So the very end is Constitution. And within that Constitution, it makes two to make a party, which is the people and the government, and which is also the soldiers and the people to enforce it. So now, another way that the judge may practice law is where they're trying to adjourn the court date. You agree to a certain court date, and the prosecutor agrees to another court date, but the judge wants to give you a different court date. Objection, Your Honor. I object on the record as a mistrial, as an appealable issue, as practicing law from the bench, as a violation of Title 28 United States Code, Section 454. Your Honor, you're defending the case. I'm telling you, this is the court date. The prosecutor agreed, and you're extending it beyond. Now, just because you set another date, now they're willing to change it to that date, but I object. I say you're practicing law from the bench, and that's a high felony treason. So you always put this on the record. They continue, fine, you continue. You can say as prejudice. This is prejudicial conduct, Your Honor. Everything, object all the way to the end, You're the people, everybody's bound to the people. But you have to know how to articulate your arguments. Now, if you say you're a citizen, there's case law that says the citizens are synonymous to the people. But if you don't use this case law, remember, hit me up, make a comment, and then I'll put it on the link on the video. If you don't hit a comment and all that, I'm expecting you to do your own research. But there's case law, and I have it. It says that the people are synonymous. The citizen and the word people are synonymous, right? But when you don't use this, a citizen becomes a citizen of the United States under the 14th Amendment, which was incorporated. So incorporated means into a corporation. It's like taken from something. And you have to know these things. You have to use your Constitution. Now, if you want to apply, everybody says that the Constitution, the 14th Amendment, is to apply to the states. Try not to use the 14th Amendment. Use the Supremacy Clause, which is Article 6, Paragraph 2, which states this Constitution shall be the law of the land, the supreme law of the land. I'm just rephrasing it in smaller, but it says, Your Honor, under Article 6, Paragraph 2, the Constitution of the United States is the law of the land, and every state is bound to obey it. And anything in any constitution or laws of any state to the contrary is null and void. I know it says notwithstanding. Notwithstanding, it means that it's not law. Okay, so a different example of a judge practicing law from the bench. There's something going on in the courtroom. So they try to do, the judge says, the courtroom is closed. We're going to run our session outside the courtroom. but then it's not being, there's no stenographer, none of that. So they tried to do that to me one time. I told them no, I want it on the record. So, so the judge wanted to do that, and the prosecutor didn't care. So if the prosecutor don't care, Your Honor, we can do it here, we can do it outside, we can do it out of the block. I don't care. Well, I care. And then if he don't care and I care, and you still want to do it in the hallway, now you're defending the case. You're going off the record. Even though you may say this is what happened off the record, I want it on the record. I want my objections clearly. I want my objections to be clear on the record. So always object on the record as a mistrial, as an appealable issue. There's many ways where the judge practices law from the bench. So now, there's times where a prosecutor is making an argument, and then the judge gives you the law, the case law, or the code that they're using. Objection, Your Honor, I object on the record as a mistrial, as an appealable issue. Your Honor, you're defending the case. They're making an argument. You're the one providing the case law. You can't help them. That's treason, because he's going against me and I'm an American. You know? Treason. Now, treason is treason by sedition. Now, when you say treason by sedition, it's that their acts, this was causing it to create treason. So whatever, you just gotta recognize something, that the judge is the third party, non-interested. Your Honor, are you the third party not interested? No. Your Honor, are you the third party not interested trier of fact of the case, the judge of the case? So that's what they are. The non-interested third party. A lot of people say they're referees. Depends on how you use the case law. Depends on what code you use. Now, a judge is a trustee position, but if you don't use the case law is, it's the court, and on who versus who, what was the opinion and what was stated and what was became law, the interpretation of the court. So now when you take that, that's called a citation. That citation becomes law. If it's from the Supreme Court, it's called law of the land. Law of the land, which makes it case law. So when people say I'm a common law free man, obviously you're saying I'm a free man, and you would look into, I believe, California Constitution or North Carolina Constitution, and that's how you would get that. You know, and you would use it under Article 4, Section 1, which says the privileges and immunities of the citizens of every state should be the same ones for every other state. You know, you don't want to use the 14th Amendment. Stay away from it. Stay away from it. Stay away from it. Stay away from it. So, everything that's in the 14th Amendment, it's in the Bill of Rights. And then, in order to apply to the states, use the Supremacy Clause, Article 6, Paragraph 2. Now, if the judge says, oh, well, that's the 14th Amendment, you're going to object. Well, Your Honor, I'm saying it's the Supremacy Clause. And right now, I say you're defending the case, because you're acting as the prosecutor. You're saying it's under the 14th Amendment. I'm telling you it's under the Supremacy Clause. Check it. Practicing law from the bench. Violation of Title 28, U.S.C. 454. So, you know, don't let him... Sometimes they try to help you, but they're not helping you. You know, 14th Amendment doesn't have all the rights. If you want the case that says that, just comment below and request the information. I will get it to you. So you have to object. He says, oh, well, in order to apply that right to the state, you have to do it under the 14th Amendment. Now, he's practicing law from the bench. He's giving you legal advice. That's a practice. That's a violation. Furthermore, you have to, whatever you feel that you should not be doing, which is yes or no, are you right or you're wrong, you stick to that. So if you feel that he's not saying yes or no, he's actually including case law, paraphrasing. If he uses something that you said or the prosecutor said it, and you guys provide the case law, then that's fine. He's elaborating, he's interpreting the law. But if he says one thing that you said, but he used a different code, now most likely he's probably not helping you. He probably will, but most likely not. So you have to catch it. You have to be on point. And that's judges practicing law from the bench, a violation of Title 28 United States Code, Section 454. Look it up, donate, stay on point. You're welcome.